My apologies for the late start. We had a guest over lunch, but I'm sure we can carry on to make up the difference, should it prove necessary.
I'm grateful, my lady. Can I? I was just on the the third argument which I'm making, which is it's not open. It would not be right. It's not indeed open to the court to say that there is a wide general common law power which further can be extended so as to include within it the power to prevent executions of, as a class, of the intellectually disabled. And I just want to make 3 points as to why I say there is no wide general common law power either to stop executions or indeed to prevent the passing of sentences on the basis that they constitute cruel and unusual punishment. The first point is this. The notion of a wide general power in the court to stay an execution on the basis that it is cruel and unusual, wide general power, is fundamentally inconsistent with the notion of a mandatory death penalty. I mean, if you have a mandatory death penalty, almost by definition, it means it's got to be passed. You can't have a law which, on the one hand, has to be passed. On the other hand, it's always subject to an exception in relation to cruel and unusual punishment. It doesn't make any sense in practice. And indeed, the odd thing is, of course, as your lordships will be well aware, ladyship, lordships are well aware, the mandatory nature of the death penalty has been held to make it cruel and unusual. But the logic of my learned friend's submission is that was all completely wrong, because it was always, the mandatory death penalty was always subject to a cruel and unusual exception. So it doesn't quite fit. The two notions are difficult to square in real life. That's what I say. That's the first point, just as a matter of what you might call high-level principle. And I say that's particularly the case in relation to a law which is now codified in statute, with very clear words. To say that it's somehow subject to a wide and general exception, it cannot be right, in my respectful submission. In particular, in relation to pronouncing a sentence. The second point I want to make on this point is this. There's no suggestion in the books that the courts ever regarded themselves, when they were exercising the power to prevent an execution of an insane man or an idiot, or indeed of a pregnant woman, that they were somehow exercising a wide general power, of which these were merely two examples, or 2 or 3 examples. On the contrary, it is always very specific points at which the law says this sentence cannot be carried out. I submit that is significant. I ask the board to bear in mind 2 points. First, there were many offences, I think in the 17th and 18th and 19th century, which were capital offences. If in fact there really was, and capital would mean subject to a mandatory death penalty, if there really was a wide general, as it were, exemption in the case where it's cruel and unusual punishment, one might have expected to see quite a few expansions of the general principle. The second and related point is that even the law of murder covers a number of forms of culpability. Again, covers a number of forms of culpability. I mean, it's notorious in the case. Now, one might have expected to see, if there was this wide general power to prevent an execution on the basis of cruel and unusual, one might have expected to see some development of that notion in the books over the last 400 or 500 years. All one actually sees is some pretty rigid exceptions where you can easily see why it makes sense applying that exception to a particular class, an easily defined class. One is the pregnant women case, the other is the insane and the idiots cases. And you can see the rationale in each case. Clear rationale, clear line of exception, which justifies, and this is my, if I may respectfully submit, a big point, which justifies a class definition. It's just wrong to execute insane people, full stop, because they don't know what's happening. It's wrong to execute a pregnant woman because she's quick with child. That's easy to understand. To say that you can extend this general principle to something which is much more nebulous and indeed more contentious, like we shall now extend this exception to prevent executions of people who are mentally disabled, as a class is, in my submission, much harder. For the reason I mentioned earlier, it is not immediately obvious that it is always, and in every case, cruel and unusual to execute an intellectually disabled person. It may well be a relevant factor to take into account, but it's not. You can't say universally that must be the case, and it's universally been recognised to be the case. And the final point I wish to make on this is this. There is a great practical difficulty in extending the law, as a related point, great practical difficulty in extending the law in the way my learned friend suggests. In my submission, that is a relevant factor in considering whether the common law does have the width of the principle my learned friend contends for, is as wide as he says. It does involve applying new concepts. For instance, someone with a low IQ who does understand what has happened is, if my learned friend is right, automatically entitled not to be executed. Just because he's got a low IQ. Now, that is not immediately obvious why that should happen to someone as a matter of class. Secondly, how far is this exception going to go? And my lords, I hope I don't sound too much like, as we're saying, floodgates, and I know it's an unattractive argument, but it's a real argument in this case. Because if you say, well, this law cannot be, the intellectually disabled should be spared as a class the carrying out of the sentence of death or the pronouncing of the sentence of death, why should it only be the intellectually disabled? Why not, for instance, people who suffer from other forms of recognised psychiatric disorder, which are short of insanity? Where do you draw the line? And it is, in my submission, a point of fundamental importance. And I make this not so much as a floodgates point, but to reinforce the point that the common law really has never envisaged this type of development. If I can put it this way, it's not capable of it. So, my lady, those are my submissions as to why this power is a limited, restricted power, not one which is, as it were, a general power which is capable of expansion and was ever intended to be expanded. Now, as well, the second part of my argument is this. Even if I'm wrong on that, and there is some wider principle than I say, which is in play despite the 1925 statute, the shall suffer death point. In my respectful submission, it was not recognised by 1985, when the law of diminished responsibility was introduced, that it was always unnecessarily cruel and unusual to impose the sentence of death in all cases on the mentally retarded or intellectually disabled, including, in particular, those categories of people which the 1985 Act did allow to be subjected to the sentence of death. And in my submission, that is important. The whole of this notion depends upon evolving standards of decency. Now, you might think, well, and in my submission, one does have to ask, and it's a bit like the point of Bow, one does have to ask, what was the position in 1985 properly understood? Because if the position in 1985 at common law, properly understood, was that there was no such wide power as my learned friend, common law power, or duty, as my learned friend contends for, then in my submission, the passing of the 1985 Act had the effect, if I can put it this way, of preventing any further development of the common law in that same area. Once Parliament has said, this is where we want to draw the line, it's not open to the courts to say, we're developing the common law so as to draw the lines in a slightly different place, in real life.
Is it true to say, I mean, I take the point that the common law has to be the route into
yes,
the constitutional attack on existing laws. That I say. But the development is that of the Constitution, is it not? It is of the constitutional prohibition rather than the development of the common law.
Well, my lady, I don't take issue with this. I accept that if there was, let's say, this wide common law duty to stop an execution in place in 1962, if that was already there, then I accept that the courts can continue in the usual way to develop the common law. If I can give a different example, take the law of defamation. the law of defamation is, as were already defined in 1962, and obviously it is, as it were, the Constitution is relevant to the law of defamation because the law of defamation touches on freedom of expression. I accept the law of defamation isn't frozen as at 1962 because it's the common law and the courts can continue to develop the common law. And likewise, I accept that the common law can always be developed notwithstanding the existing laws clause. I accept that. In other words, the effect of the existing laws clause is not to freeze the common law as at that moment. The courts can continue to develop the common law. The effect of the existing laws clause is simply to say, if the courts don't develop the common law, then it can't be struck down. In other words, the state of the law as it stood in 1962 and 1976 cannot be struck down for inconsistency with human rights. That's all. But I accept that, of course, the courts can develop the common law.
Remind me, which is the existing laws clause in this Constitution?
6, I think, is it? 4, 5 and 6 of the 1976 Constitution.
Section 6.
Section
Yeah,
6.
thank you very much.
It's all put in the double negative. Nothing shall invalidate. Yeah. But the 76 Constitution doesn't say, and you're not allowed to develop the common law. Clearly, it doesn't say that.
It's page 43.
Page 43, I'm told.
Yeah, yes.
So there's no issue between myself and my learned friend that the common law can be developed beyond what it was in 1976. But only in a way which I submit is proper, in the way the common law normally is developed.
Well, you say, as I understand it, not inconsistently with the statute.
Yes, but it mustn't be developed inconsistently with statute.
Yes, but as I said, the point is we are construing and applying the Constitution, not the common law.
Well, in my respectful submission, insofar as we're construing the Constitution, this doesn't have a submission depend upon the Constitution. If the common law cannot be extended, my lady, perhaps I can put it this way. If the common law cannot properly be extended, then in my submission, that is it. The court cannot say, on the one hand, I'm not extending the common law, but I am going to alter, I am going to rely on the cruel and unusual punishment provision in the Constitution. It cannot do that. If the common law can't be developed, and therefore the position is that the common law is exactly the same now as it was in 1962. The courts cannot, as well, help Mr. Fitzgerald by saying, well, I'm not developing the common law, but what I am going to do is to say that it's the execution of those who are intellectually disabled is cruel and unusual punishment, and therefore unconstitutional on that ground. So in other words, my lady, I submit this is not whereas I accept that Mr. Fitzgerald can get through on the common law, development of the common law point, I don't accept that he can get through on the basis of a construction of the cruel and unusual punishment clause. That, I submit, is, and that's because of the existing laws clause. And that, my lady, is why the common law point is so, I submit, is absolutely at the heart of this appeal. How wide is the common law? Can it be developed, as my learned friend says? If it can't, I submit, you then get to the point my Lord Hughes made a moment ago. And so, my lady, if I may develop this point about the statute, I submit that the position in 1985 was that the common law had not been developed, and no one would have recognised it as having been developed, so as to prevent the execution of a class of people on the footing that they were intellectually disabled. The common law had not developed that way, and there's no basis for supposing that it would have developed that way had it been asked at that point to develop that way. And in particular, it had not developed in such a way that in 1985, the common law power would have been regarded as it would not have developed in 1985 in such a way that even those whose responsibility was not affected by their intellectual disability, even they couldn't be executed. No one in my respectful submission in 1985 would have said, for instance, that a person who did suffer from some retardation, but not such as to diminish his responsibility substantially, should not be executed. I submit no one would have said that in 1985. And can I say why I say that is the case? If one takes it historically, there's nothing in the Royal Commission paper in 1953 that suggests that there was some wide common law power which would extend that far. Nothing at all. If one looks at Ford and Wainwright, which is reported in 1985, which I took you to earlier, that, of course, was the case that established there was this common law exception in relation to the insane. There's no suggestion there that it would also be extended as a class to those who are mentally disabled. It was limited to insanity, even in 1985. That was the understanding in 1985. And therefore I submit this court cannot now be satisfied that if, as it were, this issue had been raised in 1985, this court or any other court in the common law jurisdiction would have said, oh yes, we recognise that as a class, intellectually disabled people, it is cruel and unusual to execute disabled people. Therefore, we shall extend the common law prohibition to them. Secondly, by 1985, there were no statutes, which I'm aware at least, which suggested that, in death penalty jurisdictions, which suggested that it would be cruel and unusual, or which prohibited specifically the execution of people on the footing that they were intellectually disabled. Now, my lady, I submit this is an important point, because you'll recall in the Atkins case, one of the most important features of the case on which the majority relied was indeed the existence of a number of statutes which had been passed in the US since I think it was about 1992. And they said, well, there's a general consensus now, which you can pick up from the statutes, to the effect that it is widely regarded throughout the United States that it's cruel and unusual to execute the intellectually disabled. But there was no such series of statutes in America, or indeed in the Caribbean, or so far as we're aware, in any other part of the common law world where the death penalty existed in 1985. Thirdly, there were no treaties which in terms, international treaties to which Trinidad had signed up, which in 1985 expressly forbade the carrying out, in all circumstances, on the intellectually disabled as a class. My learned friend's case, very helpfully, in paragraph 27 onwards, page 673, sets out all the different, as it were, international instruments and decisions thereon. I think the very earliest, I think there's one reference in 1984 to a United Nations paper, but most of the development of this, what you might call jurisprudence, took place in, I think I'm right in saying, late 80s, early 90s, and after that. Now, I say, therefore, this is not a case like Bow, where you can say, had my learned friend been taking this point in 1985, a common law court would have said, yes, we recognise as a common law court that on existing principles it is cruel and unusual to execute intellectually disabled people as a class. I submit that there's no basis for saying that any principles have been established which would have led the court to that result. Now, my lady, in Bow, of course, the problem was rather different. There, what the court had to consider was the fact, I think I'm right in saying, in 1970, the argument went on behalf of the Crown that in 1973, when a constitution was passed, everyone assumed that the mandatory death penalty was constitutional and lawful. And that was the essential issue in the case. In fact, the board then went through a long analysis to show that even in 1973, it was well recognised that punishments that were excessive and not individualised would be cruel and unusual. And therefore it said even on well-recognised existing principles in 1973, a court, had it been asked to do so, would, on the right grounds, would have knocked out the mandatory death penalty. That was the essence of it. But implicit in the board's line of reasoning was, had there not been clear principles which would have led the court, already established, which would have led the court to that result in 1973, then there would have been no objection to the law. But, my lady, can I just go to one or two passages in Bow? It's in Bundle 1. Tab 7.
145.
And page 156, paragraph 28. You can see the main issue. I'm just going to ask you to just look at one or two passages of this. The appellants contended that, judged by the standards prevailing in 1973, and on the materials available at that time, ignoring developments and decisions which came later, the mandatory death penalty was an inhuman and degrading punishment. So that's their contention. Now, the respondent's position was, well, no, in 1973, the mandatory death penalty wasn't regarded as cruel and unusual. So the court couldn't, as it were, retrospectively say it was then cruel and unusual. One can pick the point up in paragraph 30, on page 157. The principle that criminal penalties should be proportionate to the gravity of the offence committed can be traced back to Magna Carta. It indeed appears that cruel and unusual punishments clause of the Bill of Rights was intended not only to prohibit unauthorised punishments, but also to reiterate the English policy against disproportionate penalties, and so on. And then, at the foot of the, you'll see towards the end of the page, a citation, I think it's from O'Neill and Vermont, which says all punishments by their excessive length or excessive severity and so on are greatly disproportionate. And after a considerable amount of authority to the same effect, which all preceded 1973, the board concluded in paragraph 35 at page 161 for 5 lines from the end. The board is unaware of any jurisdiction in which, by 1973, the mandatory death sentence was retained and it was considered just to execute all who were convicted. By one means or another, the harshness of the old common law was mitigated. Even during a period in the 1950s and 60s, when the death penalty was applied more frequently in South Africa than anywhere in the world, 21% of those sentenced to death were reprieved. And so, the point being made by the board was, well, look, there's always been a prohibition against cruel and unusual punishments. Punishment does require to be, on the whole, appropriate to the individual. The mandatory death penalty has always been inconsistent with that, and was inconsistent and would have been seen as inconsistent in 1973. My lady, what I say here, for the reasons I've given, the blanket exclusion in relation to intellectually disabled people would not have been regarded as necessary in 1985. It might have, and my lady, this is the problem, if I may put it this way. Many people in 1985 might have said, well, applying existing principles, it is going too far to execute someone who is intellectually disabled. But I also submit it would very much depend on the circumstances. And that, in my submission, makes it impossible for the court to say there was, as it were, a universally recognised rule in 1985 which would exonerate all intellectually disabled people.
Why could there not be a common law rule that each case would have to be examined to see whether it came within a limited exception?
Well, in my respectful submission, there's really no inkling of that was even regarded as the case in 1985 in relation to the real problem here is we're talking about the mandatory death penalty and an exception to the mandatory death penalty. My submission, it would never have been recognised in 1985 as that one of the exclusions of the mandatory death penalty would be some sort of roving class which would require to be examined after every trial.
Which was the case where the board held that if felony murder was a possible route to verdict, the mandatory sentence would be unconstitutional?
Miguel?
Well, yeah, thank you.
It's in the bundle.
In any event, you have my submissions, so I'm conscious of the time. I say, as a conclusion, when the 1985 Act was introduced, there was no general common law rule prohibiting the passing of sentence of death in circumstances which were then allowed by the 1985 Act. And that's really as far as I need to go. Because if that's the case, then I say it's not open to the courts subsequently to develop the law in relation to intellectually disabled people who are, as well, not exonerated by the Act. That's my sort of central submission.
Can we just follow that up for a minute,
Yes.
Mr. Knox? It's just been something that's been troubling me a little. As at 1985,
Yes.
diminished responsibility is introduced into Trinidad.
Yes.
And you make the point that that's a deliberate parliamentary choice.
Yes.
Its effect is it, to remove from eligibility from the death penalty those whose culpability is reduced
Yes.
by reason of mental abnormality.
Yes.
Effectively,
Yes.
don't give a definition, but that's the overall basis. Now, and therefore the removal of such people is consistent, is it, with the parliamentary choice which has been made in Trinidad.
Yes.
Now, we know that even without the death penalty, I'm thinking of the line of cases which ends in Erskine, but there are lots and lots and lots of them. We know that even in a jurisdiction which hasn't had the death penalty for several generations, there may well be cases in which a condition, a medical condition exists, which arguably would be diminished responsibility, but it isn't run at the trial for reasons which are entirely understandable. The two obvious ones are that it's inconsistent with the principal defence,
Yes.
and sometimes that the defendant refuses to allow it to be run. There may, for all I know, in Trinidad and Tobago, be a third possible reason, which might be linked to limited access to medical reports of the kind which are always available. We're spoiled here in England and Wales.
Yes.
But what I'm thinking about is this. If it's right that the parliamentary choice in Trinidad recognises the removal from the death penalty of those whose culpability is reduced by mental abnormality,
Yes.
is there any reason in principle why that should not be something which can be advanced at the sentencing stage, even if it hasn't been advanced in the trial?
Well, the reason in principle, I have to say, is simply this. The mandatory nature of the sentence. If you are convicted of murder,
You say
then the sentence is mandatory.
it's the mandatory.
That's that. And it's against that background that the 1985 Act draws these distinctions. That is the problem. That's why...
I know from Miguel that doesn't stand up in the case of a murder conviction returned on the basis of felony murder.
Their trouble was they were able to find their way around the existing law
Yes,
because
saving.
That's certainly
exactly,
true.
yes. That's because it was
That's certainly true.
a subsequent act, and therefore it was unconstitutional.
Yes.
Therefore, you had to do something with the supposed mandatory nature of the penalty.
Yes, I follow.
And so you read it down. So that's
So the
why that...
short answer is that it's a mandatory sentence, and that's that.
Yes, and my lords, this is the problem in the case. It's a mandatory sentence, and you're really being asked, in relation to what is obviously a mandatory sentence, to bring about an exception which is going to make it very difficult to see how realistically it is mandatory.
Well, there it is. I've asked for the
My lord, anyway, my lord, those are my submissions on the what you might call the 1985 point. We refer in our case to Holly, the Privy Council's decision on confessions and how it's not right to develop the law in relation to, provocation. It's not right to develop the common law of provocation, given that it was assumed in 1957 that it would have a certain fixed point You can't develop the common law once, in this area, once Parliament has spoken. And that's the essence of what is said in Holly. It's, for your Lordship's reference, it's bundle 3, tab 66, page 1345, at 1358. Perhaps, my Lord, as I'm very near the end anyway, perhaps I can just be forgiven for taking that. Because it is in my submission a fundamental principle which has particular resonance in this case. It's bundle 3, tab 66, page 1345.
66 or 67?
Tab 66, page begins 1345, but the relevant passage is 1358. And I can take it, I hope, fairly briefly. Paragraph 22. The majority set out as it were, what they say is the wrong turn that had been taken a few years earlier in a case called Smith in the previous paragraphs. Then they say in paragraph 22 this majority view, if their lordships may respectfully say so, is one model which could be adopted in framing a law relating to provocation. But their lordships consider there is one compelling overriding reason why this view cannot be regarded as an accurate statement of English law. It is this: the law of homicide is a highly sensitive and highly controversial area of the criminal law. In 1957, Parliament altered the common law relating to provocation and declared that the law on this subject should what it should thenceforth be. In these circumstances, it is not open to judges now to change, quote, develop, the common law, and thereby depart from the laws declared by Parliament. However much the contrary is asserted, the majority view does represent a departure from the law as declared by Section 3. It involves a significant relaxation of the uniform objective standard adopted by Parliament. Now, of course, it's not on all fours, but the basic principle is in my submission the same. And my lady, my lords, I do make this point. If my learned friend is right, really the 1985 Act did virtually nothing. Because let's say I'm convicted of murder, but I do suffer from some mental retardation. But the jury has found it didn't really make any difference to my responsibility. I can pop up at the sentencing hearing, which he posits, and say, well, you know, I do suffer from mental retardation, so I mustn't be sentenced to death. And in fact, you should either give me a life imprisonment, which is what you get for manslaughter, or put me in a mental institution, which again is what you get for manslaughter by reason of diminished responsibility. And I submit this is a real problem. In one sense, if my learned friend is right, Parliament didn't do anything very effective in 1985 when it passed the law of diminished responsibility. It removed the label, it allowed the label of murder to be put to some people, but it didn't make any difference apart from that in relation to sentence. So, my lady, that's my point about diminished responsibility. As far as international treaties...
Just
yes.
a bit more about diminished responsibility, two further takes on it. The introduction of a diminished responsibility defence came in Trinidad and Tobago in 85, didn't it? So that's post-dates the Constitution.
Yes.
Now, if it could be said that Parliament there recognised that there was a need for special provision in relation to those who were suffering from some form of mental abnormality, but short of McNaughton rules insanity.
Yes.
And if the view were taken that applied as it's been applied in some cases, that didn't catch people in respect of whom the penalty would be cruel and unusual, could there be either of two routes? One, in Trinidad and Tobago, to take it that Parliament must have intended the word substantially to embrace anybody whose execution would be cruel and unusual.
You read it down.
You read, in the particular context Trinidad and Tobago, you read substantial, which is a difficult word,
Yes.
in its widest possible sense, so as to embrace anybody in respect to whom execution would be cruel and unusual. Alternatively, to say that there was a lack of constitutionality in that Parliament, having intended to address the problem, had done so in a way which didn't meet the target adequately.
Well, they wouldn't invite, to deal with the latter point first, there couldn't be a lack of constitutionality because you would be, as it were, altering the existing law in a way favourable to the human rights.
But not favourable enough to meet a problem.
It's still, no, in my submission, that would still be saved. In other words,
Right.
if Parliament alters an existing law in favour of human rights,
Right.
but not as much as perhaps you think it ought to do,
Right.
it's still saved. As far as the first point is concerned, my Lord, it may be one would, it may be bearing in mind the need to avoid cruel and unusual punishments, one would place a more, what you might call, lax interpretation on the word substantially, but not so as to deprive it of all meaning whatsoever. In other words, substantially would mean more than minimal.
But it could mean anything other than trivial.
Yes, exactly. Exactly, or minimal, trivial, yes. And my Lords, as I understand it, there is authority to the effect that that is what substantially is taken to mean.
Well, in England and Wales, you can find authorities for most interpretations of substantially that you want. And Gold's recently reviewed them all, and I believe this court, or rather a court sitting in this building, is going to be looking at that in due course. But whereas ordinarily one would assume that a statute borrowed from England was intended to bear the same meaning, wouldn't necessarily have to follow if one was looking at particular constitutional conditions arising in Trinidad and Tobago because of retention of a death penalty and not available elsewhere.
Well, my Lord, I couldn't disagree, my Lord, on my feet.
You know, I wanted your comments on the thought.
Yes. Well, my Lord, it's not immediately obvious what the answer to that would be.
Right.
Say that presumably Trinidad was trying to copy the English law. But, my Lord, I understand the point. You read a statute so as to be as consistent as reasonably possible with a constitutional provision.
Yes.
But, my Lord, if that is right, if that is right, then I submit that assists my argument today.
It might be that the other side shouldn't be dropping diminished.
Well, well, my Lord, no, there is some finality somewhere. But in any event, my Lord, I submit that as a possible answer to the conundrum. My Lady, I'm conscious of the time. Can I deal very briefly with the other points, simply by in quick terms? The first is the international treaties point. I submit there's no ambiguity in the common law. And therefore, it's not open to say, well, look, Trinidad signed up to various treaties, therefore you should read the treaties. You should interpret the common law in line with the treaties. First, so as I say, first, there's no ambiguity. We know what the position is at the moment. When I say is, it has so far been declared to be. And in my submission, therefore, it's not right to look at international treaties. There is a more fundamental point, which in my submission is this. It is, in my submission, not right that you can look at international treaties to tell you what either the statute means or what the common law is, if they post-date the declaration of the common law or the statute. The point is moot at the moment. We refer to it in our written case, but in Boyce, which you can see at Bundle 1, tab 8, at 168 is where the case begins, it's page 183, at paras 25 to 26. And we say, if it really is the case that treaties entered into after a statute or after the common law has been declared can affect the law, then that is implicitly allowing the executive to alter the course of the law by treaty-making powers. It can't be right. And we're not aware of any authority which has actually considered this point and said that the court can do that. And in Boyce they say, well, it's not so clear. My lady, can I just turn on can I just refer to Atkins? Briefly, you've seen it, and I just want to make some submissions without going to it. First, the law that was being attacked was a universal law. In other words, it provided that the death penalty could be imposed on people who are intellectually disabled, without distinction. So it's quite unlike the Diminished Responsibility Act, which draws a distinction. So one can see, therefore, the problem the Supreme Court had was either strike down the whole law or preserve the law. If you strike it down, it may well be that, actually, some people who perhaps should be subject to the sentencing murder will be let off. And that was the point made by Mr. Justice Scalia in his dissent. On the other hand, if you preserve the law, then if you allow the law to stand, then you will be exposing many people to the sentence of death who shouldn't be. And so that was the decision in Atkins. They were not considering the situation we have here, where you already have a law of diminished responsibility, which draws a distinction between different, as it were, people with different intellectual disabilities. So in my submission, it doesn't take you very far in deciding what the position should be of common law in Trinidad and Tobago. If I can just very briefly deal with the second general issue, what is the ambit of the exception? Well, my lady, my lords, you'll see we say there should be no exception to to Section 4. In other words, the common law principle for which my learned friend contends doesn't exist, or if it does exist, it applies only in relation to carrying out a sentence, not pronouncing a sentence. The third question is, how should a sentencing exercise be carried out? My lady, I accept this. If there is a common law power to prevent execution, it necessarily follows that the courts must have a common law power to do something about it. One doesn't get into modification under the Constitution or anything like that. The common law power, if it existed, was a power to stop the execution. Formally, you needed a pardon, as it were, to get rid of the sentence. But I would accept that the pardon was always a mere formality. So therefore I submit that I accept that if there is this common law power to stop the execution, you don't need to, there's nothing complicated needed. The court just needs a procedure by which to exercise it. It may well be that there will have to be the imprimatur of the executive to quash any sentence that's already been passed. But that would be a matter of course rather than a matter of mercy. So I accept that. Conversely, my lady, I submit if in fact there is no common law power, then we don't even get into the third issue at all. Can I just also put in one final point about Lewis? My learned friend knocked about the prerogative of mercy. If one looks at Lewis, in my submission, it's quite plain from Lewis, which is about the advisory committee's role in Jamaica. It's quite plain from that the general principles applicable to judicial review should apply. Lewis doesn't in turn say that reasons would have to be given by the advisory committee because it didn't come into it. It did say, however, that if the advisory committee rejects a report of an international body for mercy, then it should give reasons. The implication of that, I respectfully submit, is that, of course, an advisory committee does have to exercise its powers properly in accordance with the usual principles, and therefore it's not right, as my learned friend says, that the advisory committee is a thoroughly unreliable or unreviewable body. It is a properly reviewable body. And that should be taken into account as we're in deciding the questions you have to decide. My lady, unless there's anything else, those are my submissions.
Well, thank you very much indeed, Mr. Knox. Mr. Poole?
My lady, just very briefly in relation to the first point, the confession, can I just make one thing clear? The Court of Appeal found at page 344 that Professor Kopelman had not seen the appellant. In fact, you can see from the affidavit of Saul Lerfreund that he had seen him, but his meeting with him the day before was cut short by the prison officer.
Well, he was only allowed to visit, not to do a proper examination.
Yes.
Medical examination.
And he gave that evidence.
Yes,
in the
yes,
Court of Appeal.
yes. Yep. So that was an unjustified finding, and the court already here, the board already has the evidence. The experts were aware of the evidence that he gave at the voir dire through that there had been a summary of that in the petition, but had never seen the voir dire, the details of the voir dire. My learned friend made the point, what is new in the evidence at trial? Just can I make these short points? Father de Vertet had said he was slow, that's at page 1038. The aunt at page 1049 had said that he had fallen and damaged his head and been slow as a result. The new evidence, by contrast to that, was Wayne Sturge, his lawyer, saying at page 228 that because he thought the confession was not in his language, and that was from his knowledge of him, he thought it would be helpful to have a psychological report. And you've seen that he gave various reasons about why he didn't pursue that. But one of those in his earlier letter was that he didn't think that there were funds available for it. Secondly, the new thing was that he qualified for a formal diagnosis of intellectual disability. And thirdly, and that's it, on the 52 test, he's in the bottom 1%, and very significantly impaired on the 67 IQ test, he's in the bottom 2.5%. And then finally, there was evidence of a suggestibility, which is at EB 19 in the report of Jessica Bramham. Those are the only points I make. As my lady observed, experience has shown that from Confay case onwards, that people suffering from what was then mental deficiency, now intellectual disability, do have a tendency for various reasons, not always compliance, but to either make a false confession or not do themselves justice. And I do invite the board, we've set it out in the case, to look at the confession to see whether in fact, if one looks at the rather deadpan way in which he describes things, whether that rather deadpan description would have done him justice before a jury, and if he'd had an appropriate adult or a lawyer, the obvious points, well, I never expected it to take this course, I never intended it to take that course, might well have been drawn out with the assistance of a lawyer or an appropriate adult, instead of which...
Is that a submission that the appropriate adult could suggest what his answer might be?
No, but but a lawyer certainly could help him to formulate what his legal position was. That's to say, were you surprised? Instead of which he just says, I saw it.
Right.
And he doesn't say what his reaction is. And you can have assistance and advice from the appropriate adult and indeed from the lawyer. But those are the only points I make in relation to the confession. On the Joji point, my learned friend says we need leave. We've made our submissions as to why, in fact, the matter being properly before the board, we would respectfully submit that there is no need for special leave. But even if there is need for leave, we say that the case of substantial injustice has been made out. And that is because, as the members of the board observed to my learned friend, there would at least have to be a resentencing exercise based on the fact that a conviction on the basis of manslaughter would have to be substituted, and that would be a whole different picture. So if you have manslaughter substituted, and we've dealt with this in the further note overnight, if you have manslaughter substituted, we respectfully submit, it would have to be a substantially different sentence, even if there could be a life sentence, which we question in the light of the guidelines given in the felony murder sentencing case. It would not possibly justify the identical 40-year minimum period that was based on a finding of malice aforethought and a finding of murder. And if it was on the felony murder basis, then the board has the Court of Appeal's own guidelines as to what sentencing principles should apply. And I think it's at paragraphs 36 to 37 of the sentencing case on felony murder. They're effectively saying that it shouldn't be a discretionary life sentence unless the person is without possibility of reformation. And they made an express finding that did not apply to him in fixing the tariff term on the murder case. So we say, just as a matter of basic sentencing principle, it could not have been the same sentence if a manslaughter...
Where are the guidelines?
The guidelines are in the case that we provided to the court. I think it's the Christopher case, which we've set out. Yes, Nicholas, Tan and Lewis.
Yes.
A life sentence should not be considered as the automatic, and should be reserved for cases where the opponent is beyond rehabilitation or reformation. That's at paragraph 59, but at paragraphs 36 to 37, they gave the reasons why. And on the facts, the of this case, they found in passing the sentence on the murder conviction of life with a minimum of 40 years, that he was not beyond hope of reformation. So if you add that factual finding to the approach indicated by the Court of Appeal in the case of Nicholas Tan and Lewis, then we submit it would have to be a very different sentence. Not a life sentence, but perhaps a very long fixed-term sentence. And of course, in fixing the length of that term, the very factors which led to the reduction of the death penalty to life with 40 years would still apply. That's to say, he would be entitled to say, I was sentenced to death, I was on death row for many years, and an unconscionable time was taken by the courts determining my appeal. All those mitigating factors which operated to reduce the death penalty to life of 40 years would operate again in relation to what the appropriate penalty should be on a manslaughter verdict, because he went through the same experience, whether he's guilty of murder or manslaughter. So it's not as if you'd forget about those mitigating factors, that they would still apply, but they would apply to a lesser offence, or an offence of murder on a different theory. My lady, my lords, that's what we say about why there was, at the very least, on that basis, a very substantial injustice. My learned friend fairly accepted that if the sentence would be radically different, then one could say, well, that's a substantial injustice. And we say that applies here. I won't repeat the point that he did face imminent execution. He's one of the few people who actually was read a death warrant on the basis that this was a case of capital murder, a case of mandatory death penalty. My lords, if I can then move on very briefly to our points. Of course, we invite the board to consider the further submissions we put in this morning, and the supplementary case dealing with the point that diminished responsibility, the introduction of diminished responsibility somehow removes the common law and constitutional protection that we invoke in this case against the sentencing to death of those who suffer from unsoundness of mind. But can I make these 6 points in reply? My learned friend says that the language of the 1842 ordinance and the language of the 1925 ordinance, shall suffer death, is mandatory and excludes any room for the exception that we advocate. As my Lord Clerk observed, it cannot be literally interpreted. It simply never could. It always involved an exemption in the case of expectant mothers, and I think there's only one case in all the century we can find where a pregnant mother was allowed to have the baby and then executed, and that was a serial killer in 1877. So the invariable course was to reprieve and then commute. It couldn't possibly have been mandatory, shall suffer death, in the case of those who suffered from insanity which then persisted. And therefore it could never be literally interpreted. Now, that does have importance, because once it cannot be literally interpreted, it is subject to exceptions, and we respectfully submit that those exceptions are capable of development in accordance with constitutional and common law principles. The second point, my learned friend significantly accepts that there is a common law prohibition on execution, which he accepts extends to what the common law originally described as idiots, but in which he would now accept extends to mental defectives of certain types. Now, once he's accepted that that common law prohibition on execution actually exists, it's a principle of law. And if there's a principle of law, we respectfully submit that under the Constitution based on the separation of powers, it cannot be a prohibition of law that's policed by the executive. It has to be a principle of law that is put into effect by the judiciary and put into effect when the issue arises. And I've took the board to the case of CPSAD, and I won't remind you, well, it's there, and we cited it in the speaking note. I would also just refer you to the case of Mollison, which, can I just give you the reference? It's at volume 4, tab 74, at JB 1726, paragraphs 14 and 15. And what those cases show is this. If you are challenging the mandatory death penalty or the death penalty on the mentally unsound on the basis of section 4 and 5 alone, section 6 has some application. And then you have to find an existing law that is preserved. But if the challenge is based on the separation of powers, you are not relying on section 4 and section 5. And if you're not relying on section 4 and section 5, section 6 has no bite at all, because all section 6 says is you cannot rely on section 4 and 5 to invalidate a law. And that's made very clear by Lord Bingham in Mollison. He says, if you're not relying on one of the enumerated rights in the Constitution, but on the principle of the separation of powers, which pervades the whole Constitution, then the existing law's protections don't apply. And so we submit, once that...
So is that paragraphs 14 and...
Yeah, yes, my lord, yes, paragraphs 14 and 15. Okay. Well, I can take the board to it. It's at volume 4, page 1726. Yes. Page 1728. I'm so sorry. And there he says that section 26.8 was the existing law's protection clause. And he says the validity of section 29, that's which provided for detention during the governor's pleasure, could therefore not be impugned, even if it was inconsistent with those subsections. That was the argument of the Director of Public Prosecutions.
Paragraph 13.
And then paragraph 4, well, can I just, paragraph 15, since the respondent's challenge, that's to say, in fact they were the prisoners, did not depend primarily on incompatibility with any provision of Chapter 3 of the Constitution, that's the parallel in Jamaica to 4 and 5. Section 26 cannot be relied on by the Director to defeat it. And then at the very end of paragraph 15, he says, Section 4.1 of the order cannot be relied on to defeat the defendant's challenge based on the separation of powers. And at paragraph 13, he's made it clear that the Court of Appeal, who had found that the provision was unconstitutional as a violation of the separation of powers, had relied on Hines, the separation of powers case. It does indeed appear, he says, that the sentencing provisions under challenge in the Hines case were held to be unconstitutional, not because of their repugnancy to any of the rights guaranteed by sections in Chapter 3 of the Constitution, which is the Jamaican equivalent to sections 4 and 5, but because of their incompatibility with a principle on which the Constitution itself was held to be founded, and that's the principle of separation of powers. So if you're relying on the principle of the separation of powers, Section 6 has no bite at all. And we say, once it's clear that there is a principle of law which prevents execution and a practice of law which involved at least some involvement of the judiciary in ensuring that that principle was given effect by way of the reprieves, then we say that reliance on the separation of powers is not defeated, and cannot be defeated by Section 6. And so we say that a judge, the principle that a judge should not now, after the Constitution comes into force, pass a sentence that cannot lawfully be carried out, is a principle guaranteed by the separation of powers upon which the Constitution is founded. Our fourth point, therefore, is that Section 4, therefore, of the Ordinance has to be interpreted as permitting judicial determination of whether the prohibition applies in an individual case, the prohibition on the execution of those of unsound mind, where that execution would constitute cruel and unusual punishment. Our fifth point is Section 6 is no bar.
Sorry, could you just restate your fourth point?
Yes, therefore Section 4 of the ordinance has to be interpreted as permitting a judicial determination of whether the prohibition applies in any individual case. That's to say, the bit that we say should be read in, except where it would be cruel and unusual punishment because of unsoundness of mind, the exception to the shall suffer death has to be the subject of a judicial determination, and it has to be a subject of a judicial determination once the Constitution is in force at the time of sentence. And so if one takes the case, the easy case, as it were, of the extremely insane person who simply has not run it at trial, the judge simply could not, consistently with the separation of powers, sentence them to death. As my Lord Hughes put to my learned friend, the Erskine case makes it clear that this is not fanciful. It happens the whole time. Erskine was so disordered that he simply didn't let his lawyers run diminished responsibility or even insanity. He just said get on with it. But there was no doubt he was suffering from schizophrenia at the time of the offence and at the time of the trial. And there were countless other cases. Winston Solomon, a case which was sent back by the board to the Court of Appeal, where again he was running a daft defence of alibi, when in fact he was someone who had been in mental hospital, attempted suicide. If our prohibition applied, the judge simply couldn't go through the farce of sentencing someone like that to death when they're plainly insane and they haven't run an elective defence. Our fifth point is that Section 6 is no bar. Perhaps this is repetitive because it doesn't bite on, one, a pre-existing law, which we say there is, and two, arguments based on the separation of powers.
Well, you've said that before.
Yeah, I'm so sorry. Yeah. And then the final point is it's not necessary to our argument that the common law prohibition should have been on pronouncement rather than execution. Because once the principle is there, the principle of separation of powers dictates that it should be determined when it arises. My lady, my lords, those are the basic points we make, just to very
Would
short...
you be kind enough to put those on a piece of paper, typescript? Because I'm not sure that I have a clear note of them.
I'm so sorry, my lord.
That's quite right. I'm not complaining.
I'm
Thank you very much.
do I have what my lady...
I think you can go on for another couple of minutes.
Thank you, Manny. Well, okay, as to... My learned friend says there's no wide general power to stay on grounds of cruelty. No, but there were certain recognised exceptions based on mental unsoundness, and in applying those exceptions, which have to be read in, we say that the judiciary should now apply those exceptions and apply them at the sentencing stage. At the final point, my learned friend played great reliance on the introduction of the 1985 Act. We dealt with that in the supplementary case at some length. Essentially, we say that the 1985 Act is not directed, it doesn't have an identity of subject matter, although there's obviously an overlap. But it doesn't have an identity of subject matter to the prohibition that we rely on, which would apply and bite once at the sentencing stage the issue of mental disorder invoking the prohibition came up. And again, it is not fanciful. It happens the whole time in the discretionary capital sentencing system that those who have run a conventional defence of exclude my confession, alibi, all that, then at the sentencing stage raise the fact that in fact they have some mental defect, some personality disorder in some cases, or some plain mental illness, as in the case of Ray's, Winston Solomon, Cardinal Williams, and numbers of other cases. Fox was one case where it went back and it turned out that there was a mental disorder. So there's no identity of subject matter. And again, because it's an elective defence, which you may not elect to run very often, it isn't raised, whereas this is a compulsory inquiry, we say, when there are facts to alert the judge to the fact that the prohibition may apply. And, my lady, my lords, really the rest of the points about the...
Well, you had them.
Yes, are set out, but the other point is really the point that my lady put to my learned friend, which is if, when the 1985 Act comes into force, there is a constitutional prohibition already in force, and it's a constitutional prohibition, not just a common law prohibition, then the Constitution is the supreme law, and the 1985 Act is a law introduced after the Constitution to which Section 4 and 5 necessarily apply. You cannot abridge the constitutional rights by the 1985 Act. And so, in 1985, they couldn't abridge those constitutional rights, and the statutory provisions would be subject to the imperatives of the Constitution. And for the same reason, the statutory provisions can't inhibit the development of constitutional principle, because the Constitution is the supreme law and takes precedence even over statutory law. And finally, my learned friend referred the board to the case of Bow and the analogy with Bow, where it was held that the mandatory death penalty was already unconstitutional in 1973 when the Bahamian Constitution came into force, and said there's no parallel here in the sense of a consensus or body of agreement internationally that execution or sentencing to death of those who are mentally handicapped would have been wrong. Well, the Royal Commission in 1953, the reference is JB 3559, says it is undesirable that the sentence of death should even be pronounced on anybody suffering from mental defect. So that's already in 1953, which is long before the 1976 Constitution, and we've shown the board the impressive body of materials which show that this prohibition is now well established. And we say it'd be arbitrary to say that the cut-off point is 1985. If these norms evolve, then provided the norm is there, provided the prohibition is there, one can't say freeze it in 1985. It has to be the supreme law which is capable of evolution and development.
Can I just ask you one last question on a slightly different point, which is, supposing we accept your submissions up to a point,
Yes.
but there still remains precisely how the exception should be formulated,
Yes.
which still is troubling, at any rate, me.
Yes.
And one of the things that troubles me about it, it's quite difficult to formulate it in a very clear way. And it may be that it will have to be developed on some kind of case-by-case basis, having identified the principle. Do you want to say anything more about that aspect?
Well, my lord, we've tried to address that point in part 6 of the note that we prepared for this morning, page 7 of the note we handed out this morning, which is your lordship's concern about the perhaps the subjective element. But if I can take you to 6.2, we say it's not left in a position, so that's at page 8, where there's no guidance. There are the standards set by international bodies interpreting the ICCPR, and we've set those out. And moreover, there is some guidance that can be derived from the principles developed in discretionary cases, where they're testing what's the rarest of the rare and the beyond all hope of reformation. In those cases, on the ground, as it were, they justify the proposition that that test has never been held to be satisfied where any significant degree of mental disorder has been found to be present. And we've cited the cases Petersburg, Canonier, Fox raised. Philip and John is perhaps exceptional because that was where a rather unique statutory defence available only in St Lucia was invoked. My lady gave the judgment, as my recollection is, but that was, I mean, these were all, if I can put it this way, pretty gruesome killings, but and not single killings, but they were cases in which the presence of some significant mental disorder, in Canonier's case, a personality disorder, in Fox, a steroid-induced abnormality, and Ray's depression. In Petersburg, there was found to be some element. All those were cases in which there was some element of mental disorder. Yes. Yes. We invite the fresh, my lord. I hope that's of some sense. But if the threshold has to be, we say it is if someone is found to be suffering from a medically diagnosed form of intellectual disability, which is a medical question, then they should not be executed. And we would say that there would be a presumption that if their IQ was under 70, they should not be executed. And the authority, as it were, the reason why 70 is a helpful guideline is set out in the note that we provided this morning. Yes, at paragraph 3.1, whatever the exact scope of the common law and constitutional prohibition, it certainly now extends, we say, to those with intellectual disability, whether mild, moderate or severe. That accords with international standards. It also accords with the approach of the US Supreme Court in Atkins. Footnote 3 of the judgment refers to the fact that mild mental retardation is typically used to describe people with an IQ level of 50 to approximately 70. And
we can read it, Mr.
Yes.
Fitzgerald.
I'm so sorry, my lady.
I'm sure you have now had your half hour to which you are entitled, despite my late arrival in court and Mr. Knox going on for a little bit longer than he was entitled to. So I think,
Thank you, my lady.
rather than repeat things that you have already said, I think,
my lady,
especially as I must ask Mr. Knox if he wants to say anything about Mollison, because I think you introduced that for the first time.
It was in the case. Oh.
Well, it is in the case. I
Yes,
quite
it is in
agree.
the
Yes. Thank you.
All I'd say about Mollison is this. It's not clear on our side quite what all this separation of powers point actually goes to.
We'll try and work it out.
I concede the point. I concede what Mollison says.
Point, but
quite where it takes one. Bearing in mind the concession I made, I'm not so sure.
Well, thank you very much indeed. And thank you to all counsel and everybody who's been involved in the preparation of the voluminous quantities of material that we have. We realise that a heavy responsibility lies upon the board, and we will take it all away with us and do the best we can. We will let you know the outcome in the usual way. Court is now adjourned.